Uh, I completely lost the track of the matter.
Just quickly, I'll tell you, Sachit, what is the. Quickly, I'll tell you. In fact, this SOP in question got closed as an effect of Supreme Court's judgment in state of Tamil Nadu versus K. Balu.
That is a national highway, 200 or 300
correct.
meter.
1/4/2017, the SOP got closed as an effect of the Honorable Supreme Court judgment. Now, after the judgment was passed, government gave a chance to the licensees to shift the SOPs beyond the permissible distance. Now, this incidents of shifting, if you would see, there are 5 instances we have tried to shift the shop. On some occasion due to public objection, some occasion due to the shifting could not be completed. Now, finally, after 2 rounds of in the third round of litigation, when I approached this Honorable Court, Lordship will just see page 22. This Honorable Court, in the matter, kindly see, sorry, page 18. Page 18. It starts from page 17. The order passed by this Honorable Court. In the third round of litigation, on my shifting proposal,
yes,
government came out with an instruction. Kindly see page 18, bottom 4 lines. Bottom 4 lines.
Yes.
Hence, the new site of plot so-and-so seems to be feasible for opening of so-and-so subject to relaxation by the government. Now, government came with this instruction before this Honorable Court. Relying on this instruction, my matter was disposed of. Now, when the process for shifting took place, government communicated me an order that you pay the entire license fee from the day of closure till the day of shifting.
From the date of the
closure,
okay.
17, 1/4/17, till the shifting is allowed. The whole period I did not have license. Government compelled me to give a consent to pay the license fee for the whole period.
Okay.
There are 2 aspects. Lordship has primarily taken a view that since I did not have a license, I did not have a contract with the government for minimum guaranteed quantity, I am not liable to pay. There are judgments I have cited before my Lord's Lord. I can repeat those judgments. There.
Appears judgments.
If there.
Which
my Lord Justice Pathak. Yeah, I would copy them. Let's see the first judgment, para 7 and 8. Here is a case, shop got closed on account of public objection. Licensee could not open it. Kindly see para 7. Another important fact is to be noted here under that the petitioner was operating his CS license since till the day of temporary closure. That is, it is admitted by the learned counsel for the state that the site where the operating his CS shop was not unobjectionable.
Where? Which para?
I'm sorry, my lord. I'm so sorry. It's para 7, my lord, of the first judgment. I'm so sorry. Lord, is it, let's say, 2015 SEC Online 286? 2015 SEC Online 286.
Yes.
Lord, here is a case, shop got closed due to public objection. Till the date of reopening, government was demanding the fee. This is the thin line of difference. Another important fact. Let's got it.
Yesterday, I have taken a different view, taking into account that particular that is the B&O Act 26(2).
Big pardon.
This judgment you are referring, what is this B&O Act?
Achha, Bihar and Odisha Excise Act. The same act. The earlier act. I'm sorry. Now it is Odisha Excise Act. Prior to this,
but
that
Odisha
was
Excise Act is different. Section 26 is differently worded.
A little difference is there. Little.
And then I have quoted 33 also the rules.
Bihar and Odisha excise rules. Now it has also been amended. Odisha excise rules.
Yeah.
Kindly see para 8 also. So the short point is when the shifting or non-operation of a license is attributable to the licensee.
I understand
that's
that when the temporary closure was there.
That's the point. And the incidence of shifting, your lordship, see, I have prepared a chart. How many times he has attempted to shift it? Just to assist your lordship, I have prepared an incidence of shifting. This is our fifth time. Kindly see, Lord. Every day. This is the
Yes.
Lord, one more just material. Lordship would see Annexure 18. Government looking at this contingency, page 78 of my brief. In
Page
page 78 of my brief, Annexure 18.
18.
Government, my lord, kindly see, my lord, page 18, 20th of November 2017.
Yes.
But this is in case of those shops got closed and paid the license fee on account of Honorable Supreme Court's order. Government has made provision to adjust or refund those license fee. Kindly see.
Yes.
So you have made provision for these kinds of shops, so it got closed, either to adjust or refund. And here I am also closed, and I am applying for shifting. You are allowing in 2021 from 17 to 21, and you are comparing.
Now there was a relaxation subsequently given by the government in that Tamil Nadu judgment.
Yes, distance factor.
Distance factor.
That is there. See, Lord, 1611-17 is the first order. Then 2312-2018, 20 on 1512-16 is the first order. I have filed those two orders here. Kindly see those two orders there.
Page 42.
Page 42, your lordship would kindly turn. Kindly flip over to page 42. Para 29.5. The first order.
Page?
Page 42.
Yes. Yes.
The 15/12/2016 first order closed every shop 500 meters from the outer edge of the National Highway State Highway got closed.
Yes.
Then page 48-49, lordship would see. First relaxation in case of municipality shops, para 7, bottom paragraph 7, page 48. In case of municipalities, they relaxed it. Honorable Supreme Court relaxed it. One second. The original order got modified. Para 7.
So it says that it does not really prohibit any shop within the municipal area.
That is municipal. It's not coming in municipal area. So that's the relaxation I'm just showing to you. Now, next is page 55. For panchayat area, that relaxation was made applicable, leaving it up to the government to for page 55 para 8. This is order dated 23/12/2018.
Yes.
23/2, I'm sorry, 23/2/2018, page 55. This is relevant. Having regard to this direction.
Which one? Paragraph 8.
Right.
Which line?
But having regard to the directions of the view that state governments would not be precluded from determining whether principles which have been laid down in order dated 11/7/2017 in so and so would apply to the areas covered by local self-governing bodies and statutory development authority. We are inclined to allow the state governments to make this determination since it's a question of fact as to whether an area covered by a local self-governing body is proximate to municipal agglomeration or in some. So this relaxation, they allowed the government to take a decision, and government took a decision for panchayat areas that within 220 meters of state highway, they will permit these kinds of shops.
Where is that?
But that is there. It is but that is not part of the record, but that's the admitted position. That is undisputed.
Anyhow, that position is not here because you wanted a shifting.
Right.
Your question is that you wanted a shifting.
We have been, yes. Finally, they have agreed to shift it.
Where is
but that is annexure 1.
Side?
That is annexure 1, my lord. Page.
Disputed sides.
Yes, my lord. Now government has agreed over this side, subject to relaxation. Kindly see annexure 1. In their counter also they have admitted. Page 23. Before that, would your lordship look at their counter where they have admitted? Kindly see their counter. 23 is the order, my lord, wherein the government has on principle agreed, but has put a rider with regard to this deposit. Kindly see.
Annexure 1.
What I'm looking. But he may intimated to give her consent to deposit the pending license.
Yes, this is the rider. Kindly see their counter also. That is at page, internal page 3 of their count, para 7.
Counter.
Internal page 3, para 7 of the counter filed by OP number 2, 3 and 4, internal page 3, para 7. Running page 82. Just a small paragraph.
Just 1 minute.
Lordship will gather paragraph 7 that it is respectfully submitted that the tenor of the language contained in the government order clearly shows
So
that
it's a really repletion of
yes,
their
they have on principle agreed.
the page 23,
Yes.
connection 1.
Yes, yes. They have agreed. But only rider is this 1819 up to the shifting, which I am not liable to pay for Lordship sees section 29 read with section 35. A person, a licensee is liable to
Section
pay.
29
Section 29 is the duty for the and 35. And 29 is duty, 35 is the license fee. It is only for a license. When a person is having a license, act, my lord, act. An excise duty. An excise duty or countervailing duty. Let's got it.
yes, I got it.
Of such amount as the government may by notification specify from time to time shall be levied on liquor permitted to be imported, exported, manufactured, issued from any manufacturing institution sold under provisions of this act or rule notification, license or permit issued under thereunder. It is only when a license is there. Similar also in case of fees, section 35.
So section 39.
35.
35.
Payment for grant of privilege.
That is regarding the MGQ.
When 29 is MGQ, 35 is
to the
license fee. Yes.
Except the payment of
fees. Only for a license. Now from 17, 1/4/17 till you issue me a license, I have no license.
Yes.
And this closure is not attributable to the licensee. It's on account of the Honorable Supreme Court's order. So, Your Lordship,
there is a reference of one writ petition filed by you.
so 3 writ petitions I have given those orders. Yes.
In the annexion 1.
Yes.
What is that writ petition?
That is page 18 order.
Oh, this is
that yes, I have just read out that order.
Yes.
Page 17. Okay. Page 17 starts from page 16. The number is there, my Lord Justice, Honorable Justice. Kindly page 16. That is the complying with that, they have passed this order. And Your Lordship will see they have accused to the extent 17 is concerned. 1/4/17, 1/4/17 till March 18, they are not saying I am liable to pay. They have accused. Now 18, 19 onwards they are saying.
March 17 to
First 31st of March 18, they are not saying that I am liable, despite the same period is covered. But 18, 19 onwards they are saying.
Because yesterday we had an occasion to deal with two provisions in a different way. That's a provision of temporary closure.
26.
and subsequent objection after the renewal or in the midst of the
Section 41 proviso
no
that it can't be.
33
33
33(2).
33(2).
That's the rules.
Rule 33.
Rules 33(2).
One second. I'm telling you. I'm just coming over there. 33(2). Objections. Yes. Any objection received after the cut-off, after the period shall be summarily rejected. 33(2). Lordship will read it along with section 41 proviso.
That is no proviso. 41 proviso is
something which says once a shop is operating for a period of 3 years, thereafter no objection will be entertained. Or no, usually the word is lordship will see. Your lordship had
it is what I have said, that there are two things which came before us. One was section 26 of the Act,
objections.
where there's the only provision contemplates about the closure temporarily.
Section 26 is only provision. District magistrate or sub-divisional magistrate.
Correct. It was not entrusted upon the sub-inspector of exercise or something like that.
That's the matter I was handling, Lord. I was only pleading before your lordship.
You argued that matter?
Yes, Lord, I argued it. Lordship were pleased to pass an interim order to directing opening the shop.
So this is what I find, that these are the principles. Temporary closure. It was because of the judgment of the Supreme Court they have no other options.
So that is the it's not the
That
case
is
of
in compliance of the judicial order. It was not under any of the
exactly no, any of the provisions. No.
That is what I really wanted to make a distinction.
Yes, yes. So grateful. That's the. To the extent
that the conditions which have been put in is unreasonable, contrary to the provision. Ms. Rai, who argues earlier?
Patnaik was the matter.
Yes.
Patnaik is not there.
Mr. D. Nayak. No, who was arguing?
On the last occasion, Ms. Patnaik was present.
Where? I do not find.
On 21/7/2025.
Okay. No. You are interested in the brief.
Actually, Ms. Patnaik is to conduct the matter because she was.
This is what is the he has not said it.
My predicament is, the counter affidavit actually is silent on many aspects. Like there's nothing for me to go on.
So we'll go through the counter and then
that is the predicament. The counter affidavit does not actually reflect.
So what can you
because Ms. Patnaik was handling the matter.
Anyhow, nothing. We will go by a counter. Nothing more was really concluded, but since we lost track of the matter, so now the matter was placed before this court, inviting the
We heard it already.
What?
We are to pass on.
Oh, yes. No substantial question of law. We have decided what is the meaning of the substantial question of law.
Mr. Tushar Satpathy was there. Yes, sir.
I will intimate.
It is against the revenue.
I will intimate.
We have held that every question of law is not substantial. What should be substantial? We have decided. Yes.
Item number 2.
I have,
We have
I have already filed the second copy, but it has been, might have been misplaced. Might have been misplaced, but I have filed the second copy earlier in this court.
I should not get. Oh. So we have said that the revenue authority is not a competent authority to file a revisional applications, and we have satisfied that order. Directed the mandate has been given. We have not accepted your contention of compensation because we held that unless the proceeding under section 8A is complete, the right does not accrue to you.
Yes.
Unless that right is accrued, you are not entitled, and therefore directed the 8A to be disposed of within a time.
Or the certified copy. Or the certified copy.
Judgment is delivered, sir. Go through the judgment.
Yeah.
Yes, call.
Item number 3.
Yeah.
My lord, there was that profile that was made by the lady.
That has been withdrawn by mistake. I am signing an affidavit copy.
Can I have a copy?
That has been by mistake, unintentionally that was done, but immediately thereafter it has been. In fact, that is a mistake. I also last date made a statement that
So you have already withdrawn everything.
not only
Yes.
withdrawn, she is begging apology that by mistake
lord,
she has done it.
My lord, I have proof that it was deliberate and operating. I am not pressing it. My lord, I'm not pressing it.
Once
I am not pressing it.
realized this
Yes,
mistake and
certainly, my lord.
remedied it,
Certainly, my
I
lord.
don't think so that you should be.
Certainly. I'm not, my lord. I'm just putting it to my lords that it was the.
Where is the girl? Sorry, the child, whatever.
My lord, he is in Bhubaneswar, my lord.
She is now she has filed an
Item number 5.
May I please, my lordship? My lordship, is the content petition on challenging the non-compliance of order dated 16/7/2020.
The non-compliance or
Non-compliance of the order dated.
not challenging,
Sorry, my lordship.
informing the non-compliance.
Non-compliance.
You are an informant.
My lordship. Non-compliance of order.
Which
That is-
order, madam?
16/7/2025 in CRLMP 841 of 2025. Annexure
That
1,
was
my
also
lordship.
content.
Annexure 1, 8 to 11 page number.
Page.
Page number 8.
How this pattern has come to me. It was with Justice Chittaranjan Das. Well, one of the judges available. No general order I have said where both of them are not there. No, SD, CR. Oh, that is has we come to division. Yes, but this is.
My lordship, the FIR is registered in 2023, my lordship. And till now, no investigation is going on and non-submission of any.
Does it mean that it is a criminal contempt? Without contempt of court sanction. Whether you can file it without the concurrence of the Advocate General. No, site of police. I do not think so.
My lordship, I filed a CRLMP on direction.
So it becomes a criminal contempt. An order is passed in a criminal proceedings if violated the criminal contempt. Please show me the law. Let me understand. Have you read the definition of a criminal contempt under the Contempt of Courts Act? Section 2C. Have you read it? Give. What it says. What is criminal contempt? Criminal contempt means publication, whether by words spoken or written or by signs or by visual representation or otherwise, of any matter or doing any other act whatsoever, which first scandalizes or tends to scandalize or lowers or tends to lower the authority of any court. It is not a case. B, prejudices or interferes or tends to interfere with the due course of judicial proceeding, which is not a case. 3, interferes or tends or to interfere with or obstruct or tends to obstruct the administration of justice in any manner. Is it? Civil contempt says means willful disobedience of any judgment, decree, direction, order, rate, or other process of the court, or willful breach of an undertaking to the court. You are alleging the willful violation of the order. Is it not a civil contempt? How it becomes? Because it is passed in CRLM, so it becomes a criminal contempt. And then if you say criminal contempt, then come to section 50. Have you taken up the opinion of the Advocate General? Can you initiate a criminal proceeding? Read section 50. What it says?
Okay, sir, I need some time to, if
Some time means what it says.
my lordship, I seek a time of an adjournment. Examine and take the advice from the Advocate General, my lordship.
This matter, it is related to Annexure 1, that is the notice inviting tender.
Yes.
This is pertinent to the Annexure 1, that is notice inviting tender under Annexure 1 with a clause on.
You are appearing in notice inviting tender,
Yes, Your Lordship.
not in GST and I complaints. Okay. Yes.
There is a clause 13 at page 32. Clause 13 that says,
32.
Page 32, clause 13. The declaration for not blacklisted or criminal liability form that has to be filed by the petitioner. That is Annexure 6. That form is filed by the petitioner. That is at page 68.
Annexure 6 is
Annexure 6 of the, that is the form, and that was filed by
you
the
have to
petitioner.
say that declaration that you are not blacklisted.
Yes, I have filed that. Then you let's see at page.
What is that form? Where is Annexure 6?
Annexure 6 is at page 58.
50?
That form, 58. 58. Criminal liability undertaking. That is the form.
Yes.
That was filed by the petitioner. That is at Annexure 2, page 68. That was filled up and filed. That is at page 68.
That is what I really wanted because it talks about the last 3 years.
Last 3 years.
Yes.
So this is 24, 25. The last 3 years, 21, 22, 22, 23, 23, 24. So that was filed. But the petitioner was
Blacklisted?
no. My Annexure 3 is the impugned decision of the tender evaluating committee, and the relevant parties at page 70. Serial number 3. The
You are
petitioner.
saying number 3.
Yes, lordships.
Sumit Security.
Yes, lordships.
Blacklisted by
Yes.
additional 21.
Yes. But your
Failure
lordship.
to deposit the statutory dues of EPF.
But if the petition was never blacklisted, your lordship, because the letter and the department that was cited, that is already available. I have filed. That is Annexure page 74, your lordship.
Page 74.
4.
This is a letter, this memo you are citing.
Page 74. That was to whomsoever it concerned, to show that on 4/6/2021, petitioner was working on that particular under that particular department and satisfied the certificate of good certificate was given to the petitioner.
So what, if there
So-
was a continuing contract?
It is
then
continuing. So when it is continuing,
question
how
is of blacklisting for the future contract or a future tender, and continuance of the existing tender is two different concepts.
yes, obliged leadership.
So
This
tell me whether for future contract
the,
tender you were prevented.
this tend the letter
This was earlier continuing one.
this letter
Work order is of 2017, madam.
yes,
So
they have cited 3/5/2021 letter. The impugned part is 3/5
you could not get what I'm saying is
pardon leadership.
there is already an existing contract awarded to you which is continuing.
Yes, leadership.
Then subsequently there may be another tender which is floated where you have been found to have done something.
No, leadership. The same.
Have a patience. Hypothetically, I'm not saying you have. Let us see. A is a contractor. He has been awarded a contract. She is undertaking and doing it. Continue. This A participated in another tender. That tender, in that process, the authorities, sending authorities found certain glaring irregularities, fraud or something of that. They initiated a proceedings and then blacklisted you to, what is the blacklisting? To participate in a future tender, not to participate or preventing you. Does it impact the running of the existing contract where there is no fault on your part?
No.
How the certificate can prove your, because it's a continuing contract.
This the at that time, that point of time, that was the only contract that was petitioner was working under the same authority. And another point, leadership, for that regard, another point, second paragraph.
Blacklisting was for future contracts or
Has to be.
But there was never
for the existing contract, whether blacklisting was claimed or
future contract. I
future
understood.
contract.
Future contract. I understood, your lordship. But
They could have taken that word from.
but your lordship, there was the petition was never blacklisted.
So this letter they are referring,
Yes.
I'm just asking this letter, have you asked for any clarification from this authority that they are referring your letter? Please tell me where is the blacklisting order?
Yes, lordship. That is Annexure 6, lordship. They have not replied to that. They have not replied, and in the meantime, lordship, the work order has already been issued. But the finding has to go, lordship, because there was never any blacklisting order.
Please for the other side. For limited purpose. Who is this opposite party?
Forest.
So for us, next para, lordship, that I have already annexed that part. Next para, lordship, that is they have alleged for another department, lordship.
You give a notice and come back. Let us see. This is a limited one.
Yes, lordship. Only 5.
Give a.
And it is covered by your lordship's judgment, the care security.
Please come, serve notice and come back.
But your lordship, I may be protected versus because
Protected.
because
You say work order has already been issued.
No,
I am not on that.
not
Only thing is that this particular finding should not remain on record.
yes,
So
lordship.
what interim order? If it is passed, then what remain in the writ petition?
Your lordship, because of this
What
finding,
remain? Tell me. If we stay this particular observation, then what we will decide at the time of final hearing?
because of this finding, I am not
Please
eligible
not
for
notice. Give a
yes,
notice.
lordship.
Come back.
Yes, lordship.
Yes, notice. Requisites by today.
Yes, lordship. Today.
Today.
Filing now for the petition.
10 minutes filing.
Requisites ଆଜି ଦାଖଲ କରିପାରିବେନି, କାଲି ସୋମବାର କରିବେ।
So much should do.
Uh,
Wednesday
14.
then. Wednesday.
But that's
3 working days good.
first week of, second week of November. Yes.
For one, she is okay.
Item number,
Photocopy, sir, for me.
Yes.
item 7.
Obliged.
Corporation Limited, my lord. But often, my lord, in fact, this is an
What is
emergency
this
petition.
order dated 6/12, sir? 6/12, where is that order?
That
6/12/2020, yes, annexure 14.
That is on page 181. Annexure 14,
Just,
page. What happened, my lord? In fact, earlier, the dispute between the state electronic, Kerala State Electronic Corporation and also the Department of School and Mass State of Orissa, my lord. And in fact, there is a dispute, in fact, between two state-owned corporations. That is why earlier I came before this honorable. They said that this Kerala State owned corporation, my lord, this development corporation, electronic corporation is not at all
so
equal
what
to.
is this? You wanted something is to be done.
But my
They have said that no, this e-Vidyalaya project,
Yes,
they,
ma'am.
they say not to proceed further.
what happened, my lord, in filling the section very small. What happened earlier, in fact, a letter of award, in fact, issued in my favor. 2000 primary schools, aided school, and also government schools, computer education, and also supply of various materials to electronics. In fact, have given the award was given to me. Subsequently, without any reason, my lord, they terminate my contract. That's why I came before this honorable court. Subsequently, see page. That is page 155. That you can see. I came before this one 155. That is annexure 8.
Yes.
155. That's it. That is short. By your brief interpretation, second paragraph, though prima facie this petition has made out a good case for claiming damage for which the matter is required to be admitted, but it will not enumerate its benefit as it would take a reasonable longer period for hearing this matter. Moreover, arbitration clause is available in the agreement for resolution of dispute between the parties. However, in the course of hearing, under counsel for the petitioner submits that a repentance such and such. Then last paragraph. It would not be out of place to mention here that against order of termination agreement in 5/4/2017, as that Annex 1 series, we are inclined to admit the case, but this should not serve the purpose. In fact, it would be better for the state government to resolve the entire dispute between the state-owned corporation amicably in a commercial way. Now, what happened, my lord? Then I made
Yes, yes. Available in the third week of November and file requisites by 24. Nothing is going to happen. This has
and
been
then I'm not
nothing.
also any increment.
Yes. Call the next.
Item 8.
Okay, that's good.
requisites by next copy date.
One Union of India, one is Union of India.
24. I am there on behalf of Union of India. We have received a copy, my lords.
Yes. One Union of India, two state government. Two, three state government. No, 4, 5, 6 requisites.
Item 8.
Let the trivial issue, as I have been saying before, my lords, they have revised the MGQ. It's a stone query, sand query, sand sirer. For certain period, it was locked up in litigation before this honorable court, NGT others, he could not operate it. He applied the authority because of this, he could not operate to revise the MGQ for that period. They have revised the MGQ for that year, 21-22. That document is here. Only thing is corresponding payment, I3MS, is to be updated so that I can make whatever payment they update it. That's the
Send to the director minus minerals matter with the competent authority to actually complete the process matters.
But that is to be completed. He wanted to pay off unless you. So
Competent authority or mining, if the director of mines have all, deputy director of mines have already informed, some time may be granted to director of minor minerals to see into this matter.
come on 27, take an instruction and come back.
Director of minor minerals is not.
He wanted to deposit, then why you are not permitting him to deposit? Come on 27.
Only correction of the portal matters.
That is what he wanted.
yes.
Yes, brother. You got it.
It's some time.
27,
First,
28.
first week of November, matters educate.
There is no one. Six.
Item 9.
Your Lordship, on order dated 24/9/2025, state was directed to obtain instruction so far as the matter, my lord, the search and seizure of the material has been conducted as per the, my lord, Mines Minerals Act, which has not been done as per the rule prescribed under the Act, your lordships. Section 54 prescribed, my lord, prescribed the procedure that the search and seizure has to be done as per the section 100 of this CRPC, my lord. So that is what the government was directed last time to obtain instruction.
In this case, my lord, the question of search and seizure, my lord, search doesn't arise. What section 54 says, my lords may appreciate. Here, my lords, a stack of minerals were found stack on the banks of a river. The villagers complained, my lord. We went and we saw that the materials are lying on the riverbed. So we made a public notice, my lord. Then in pursuant to the public notice, my lord, the petitioner comes forward and says that these are my minerals. And in support, he submits certain Y forms. I have got the entire Y forms, my lord. My lords will see the Y forms. They bear the name of a place.
Bring all those facts by way of affidavit.
My lords, I'll file.
Affidavit. By 2 weeks, rejoinder 1 week, matter to appear after 3 weeks. Give or take.
14.
Yes.
Item 10.
My lord, last occasion, your lordship directed the state to take instruction.
For what?
As a matter, the petitioner has filed this writ application challenging the tender process which has been settled in favor of opposite party number 5, my lord. That is an NGO. So your lordship directed to him to take instruction. Mr. Kanungo was arguing this matter last occasion.
So he is for the petitioner.
My lord.
So now you are arguing.
My lord.
What is the matter about? What instruction?
Lords, before I hand over the instructions, my lords may for a second, 1 second, my lords may kindly have a glance at paragraph 5.3. That is the sole basis of the case. They say, my lord, opposite party number 5. It is a non-profit organization and that memorandum does not permit them to indulge in any profit-making activity.
This is
Yes,
that case.
My
My
lord.
lords. The same, my lord, the same in regard to opposite party number 5, my lords have already decided. My lords, I'm giving. That means there's nothing wrong with memorandum and they can indulge in profit making activities. There's a
3 cases have been decided.
and
I'm
a
of
cost was also imposed, Miller, for filing such kind of frivolous litigation.
25,000 cost your receive imposed.
Was it deposited?
We were not arguing that matter, Mal. We are not a party to that case. We have not filed that
No,
case.
we are not.
No, Mal.
What we are thinking whether the same treatment can be extended
Your
to
lordship.
you also.
Your lordship.
We are thinking in that line. You are not bound by it, but
So each one of the point has been dealt with in different judgments. My lord, your lordship dealt with the matter. The competitor file writ application. My lord, we are the villagers. We are not the interested party. We have not participated in the tender. We are the villagers. We just wanted that the transparency may be maintained. That has not been maintained. That is our.
transparency means
It was not circulated.
beholds the law. Transparency means the law has to be kept at the side way, and then something must be shown. What is meant by the transparency?
Your lordship, you see our ground, my lord. We have.
The point is
Ground B, my lord.
Only point is that they being a society, their bylaws or the memorandum of article does not contemplate any kind of a business. They are doing it. We have already dealt with.
Right.
What more? What transparency you want?
No, that is our allegation. That is the.
What transparency you want? Then if the law does not stand in the way, does it mean no transparency? We have referred the provision of the Society Registration Act.
It's a society, my lord, society. Society is but if individual competitors file writ applications, they have lost. And they have set up the villagers to file. May I pray one thing, let it come after vacation.
So
I will
it's a
take
collective one. That was an individual case.
Yes.
And the villagers are plenty in number.
Then now the villagers have come out after dismissal of
Plenty in number.
Right.
So quantum, I was just thinking,
Right.
quantum may vary. So appropriately pro rata basis it should be distributed.
The lordship may keep me back after vacation, my lord. Just I will take instruction, my lord, that
Another judgment, I believe I have.
three judgments, my lord. You know, it is society. Another judgment also, another tender, the society again, the same question was raised, you are dismissed.
Nothing, sir. Let list this. Did I list it or? The open theatre on Wednesday.
Item no 11. In this matter, Lordship directed the State House to obtain instructions with regard to Annexure 8. What?
Before my lord, my learned friend begins, here I am an intervener. I filed an application for intervention. In fact, in this matter, now I am appearing as a devil's lawyer.
Huh?
I'm giving as a debt
With
is
the bulk,
loyal here.
with the bulk of.
But I have applied for intervention. I'm objecting his attempt to open the shop before the
Who are you?
But I am an objector. I am an objector pursuant to format notice. Now, before the commissioner,
Pursuant to
Pursuant to
rule
orders.
31,
Yes.
pursuant to format notice, I have an objector. I objected. I approached this honorable court earlier. Pursuant to the order passed here, I approached the commissioner. Commissioner, having rejected my objections without considering documents, has recommended matter to the government. Now he is
Yes.
trying to enforce that recommendation.
correct.
I have challenged that recommendation in a revision before the government. My revision is pending. That is
I have
one.
not been noticed.
1 second.
Till date, I have not been noticed.
One
The
second.
revision.
My revision is
if I
pending before the government. In a properly constituted procedure, a revision is maintainable against the commissioners.
Let that be revision and this proposal may be considered, Your Lordship, may direct disposal, Lordship.
Yes.
It can, giving an opportunity to the parties.
Revisional, give the number.
I'll give.
Revisional.
I mean, in my intervention application, I have given entire
It's
document.
mentioned in the
Entire.
instructions also, madam. It's mentioned in the instructions.
You go
Your
into
Your Lordship,
the
Lordship.
to
Lordship, may direct.
dispose of the matter. Yeah?
Yes.
I'm not dictating.
Investigation.
And there is one more development. The government, during pendency of my revision, has directed for an inquiry, fresh inquiry. Not all those procedure they will follow, will raise it before the government.
Anyhow, yes.
Item 12.
Great.
Is the yesterday matter.
Give for order.
The item 12 is the yesterday matter. Also is going to pronounce the order. Somehow it has come again. That you also direct. In fact, pronounced that within 3 weeks they will dispose of the appeal, which was filed way back in 2019. That clearance certificate, you also remember that case. Yesterday it was there.
Yes.
May
Why it was not disposed of? Why it is dismissed?
possibly, but in fact, you also wanted to know from me also, because though I have stated in my writ application, but in fact, 20th is the last date. That is why the Form D application, that 5 years old also wanted to know from which date it starts. In fact, if you also will see, period of license is from 21 October 2020 to 20th October 2025.
Hmm. 13. 13. May please, Lordship. Earlier, this code I have approved, Lordship under Annexure 14 has was the order passed by the commissioner and directed that to pass a reason order. But now, same order has been passed. Same paragraph and has been quoted in the improved order. Lordship, can you glance at Annexure 13, page 82, and the present improved order at page 119. The paragraph, last paragraph is same.
Brief.
Lordship, can you glance page
Which
82,
one? Which?
page 82 first, Lordship. Therefore, in view of the above fact and evidence involvement in lawful activities, therefore, violating the stipulated terms and conditions of license, which amounts to misrepresentation of facts, incorrect pleadings by the appellant, his prayer for stay so is rejected. Lordships have directed in the next Annexure 14. Lordships, paragraph 5, it has been specifically stated that Lordships that to pass reason in each and every points. And now, Lordship, kind of glance to the improved order. It starts at 115 Annexure 17 and the 115 Annexure 17 and the Lordships the order rejection order last paragraph 190. Same verbatim, same thing. Entire the paragraph has been reproduced.
No.
No reason has been assigned. He has stated about the submissions of the parties. Thereafter, in the last paragraph.
What do you say, madam? Is a non-application of mine.
Lordship's violation order also. So Lordship's order.
Why not the content?
Yeah, the hearing opportunity and consideration, everything is mentioned at page number 1.
We have said in paragraph 3, their recording that the points which they have raised in the note of submissions that has not been taken up by the appellate authority.
Not a single point, Lordship. Only submissions have been noted.
Your contention was that since the notes of argument was not uploaded on the portal, the same was not taken into consideration. And then on that basis says that we set aside, oh, now you know it, what is the note of submission, you take note, you decide all the points, then what you have done?
Page number 115 para of second last paragraph just before the brief facts.
Yes.
Mention that it is pertinent to mention here that applicant find an appeal challenging audited funds for rejecting the application of the to compound funds like direct responding to open the shop. After hearing of the appeal in presence of the applicant, Supreme so and so the rejected the appeal.
Correct.
And sorry, my last one paragraph before that. That all the written note of submissions were taken and submitted and taken into consideration.
Where?
Third last paragraph from the minutes.
I do. Where?
After the quoted question, my lords, in
Yes.
accordance with the above mentioned order, the applicant Himanshu Shekhar Nayak was directed to remain present on such and such date for hearing of his appeal case. Learned advocate on behalf of the applicant and superintendent of excise cutoff were also present and heard extensively. Paragraph's comments in response to the written note of submission dated 35.
Correct. So this is the fact.
Yes.
Where you have dealt with those
That is-
submissions.
Now, each submission or each ground of objection vis-a-vis the report which was submitted by the superintendent, that has to be tested and the independent finding has to be recorded.
Your Milord, they have,
There's a revision provision under the
Your Milord,
there's
they
a
have
revision
closed
provision.
the shop and without Your Milord following the section 26. Since a past order, they were yesterday.
You have recorded simply the submissions made by such and such, and then jump to the conclusion.
Conclusion will not same. Earlier, which your Lordship set aside. Same paragraph. From starting to last, the same word, all. Not as applied his mind and passed reason order also. No reason. From 26/9, they have closed. Lord, I am approaching. This is not third time I am. And they have closed also basis of the Lordship's. The letter dated 28/3/2024, which is Lordship's reflected in the order.
It is really unfortunate. placed before me.
My.
So now he has placed, so that order is there. Now,
Only I have produced that, Lordship wanted,
that
yes,
you have in
20th
terms
is the,
of this.
20th is the last date, also refer
What is
to.
the position of?
Appeal is still pending, my lords. Appeal is still pending.
Appeal is still pending. So,
3 weeks.
how many days will you take to dispose it of?
My lords, 4 weeks. 4 weeks.
Lordship wanted
Then,
3 weeks.
What would happen to his
Very
license,
Yes.
which is lapsing on 20th?
Minimum 2 weeks, my lords. For
Then what would happen to his factory? How will he run his factory? On 20th it is lapsing. That's why it is kept
Extend
today.
it for a period of say 3 weeks or whatever, so that at least he can run and dispose of the appeal.
You also remember that judgment at division bench, coordinate bench of this court, where it was said that this minor is not covered by that judgment of the Supreme Court. That judgment also have enclosed. That will also, they can take into consideration and they can pass us.
No. Outstanding
Ah.
dues were there.
Yes.
So you say that those outstanding dues relatable to prior to insertion of these two
Yes.
minerals.
Yes.
So in view of
Judgment.
because you are not liable.
Right, sir. Right.
So now they have sent it for audit.
Yeah.
Right.
On,
So on 20th your license is going to expire.
yes, sir. But they say also kindly look to page 57. The interim stay is continuing. Therefore, they have granted in 2020.
6 months.
6 months. Yes. But they are
extended till now.
Yes. But 5 years is expiring on 20. As your Lordship.
Appeal has not been disposed of.
no, my lords, appeal is not.
So definitely the interim order is still there.
My lords, for renewal of the trading license, what is required is as per Rule 4 of the Orissa Mineral Rules 2000.
New due certificate.
Yes, my lords.
That is what is the
That is
problem.
exactly.
How it becomes due to me is the question to be decided.
Yes.
And your authority says that since there was an interim order, I extend no dues. Similar manner, since it is still pending in the appeal, similar manner, interim order is there, extend for 4 weeks. 4 weeks, that's all.
Within that 4 weeks, you dispose
of that.
3 weeks you dispose of.
So that stay will continue till that disposal of copy.
4 weeks, Lordship, within 3 weeks, they will dispose of my appeal.
Well, it's regarding stay, my
On
lords, this is the standard form in which these orders are generally passed, my lords.
We will say that the appeal is pending and the earlier occasion it was extended because of this. So taking clue there from this one. That's all. And your conduct, if you want, we will reflect that from 2019 what you are doing.
You can increase the license.